Anyway, good afternoon. When more people come in, they'll join us. In the meantime, we're dependent on these recordings to keep up. Last time I jumped ahead to social issues and talked a little bit about them. We'll go back and revisit those. It was just kind of an introduction to them because that is really where planning is right now, is trying to figure out how we can balance social equity issues when it comes to city planning, especially as zoning has been the ruling everything in planning for quite a while and has proven to be problematic. But getting back to where we are with legal issues at this point, I prepared a 3 or 4 page summary that's available as a Word document for you to download and try to give you the skinny from the text so that you would have, again, a sense of what was really important about that to try to keep up with it. Let's see, the general idea, well, I'll tell you what we'll do is we'll go through some questions and talk about them at the end. That might be a little bit more interesting than my going through the notes, and besides, you've got them. I'm expecting another student who is trying to sign in now, so I'm tracking my email at the same time. So we'll come back and we'll review this in kind of a, hopefully a more interesting way. But I wanted to kind of begin the process with a case study. As you might think, in this land of the free, we call the United States, private property rights, you know, the Fourth Amendment really has a lot to say about we can't take people's property. Taking is a big thing here. But yet, as cities started to develop, they realized that because of the proximity that people find themselves in, that somehow or other there need to be more control or feelings about it. Okay. Gabriel can't find the link. Sorry. Let's see what's going on here.
Yeah, I just scrolled down in the announcements to find it.
Yeah, that's right. I mean, I was hoping that we could do it once, but I will do it as many times it takes. Let's see. If I go back to here, excuse me, and look at the announcements and go to Thursday's class. Okay. Go back to your email. All right, I think we've done it. What was I saying? We have a conflict between private property rights and the ability of cities to intermediate and to try to make for a safe and reasonable living environment. It becomes much more important the more dense we get, that we have certain controls on people's behavior. And this is a constant source of antagonism. And it's evidence today when you see the city dwellers tend to be a lot more careful about the virus than people who are from the country who feel they already have social distancing and this is just getting in their way of making a living. That's a big brush that I'm using, but in general, that's kind of what's happening. Hey, Gabriel. Yeah, I posted a
Hey,
news
Mr.
link.
Ward.
I
Sorry
posted
about
a news link for Monday's and Thursday's class early on. I didn't repost it, so hopefully everybody will get that.
So the same link works every time?
Yep, it's a recurring meeting.
Okay, perfect.
Yeah, well, I don't know how perfect it is, but hopefully we'll get it out there. I just didn't want to clutter up too many meetings showing up separately. Anyway, so we were talking about zoning and planning and the difficulties with private property rights, and in cities where cities need to have a little bit more control over people's behavior in order to protect people. I mean, the number one job of most cities is to protect your health, safety, and welfare. And, you know, if you can't have control over where you put industrial plants or something that might be noxious, then you can't do that. And so
if those are the justifications for pretty much most regulations that cities are able to pass, how is under what power is Charleston able to do the historic district? and historic preservation and things like that? Because it
Well,
doesn't seem like that falls under health,
there
safety,
is a
and
gray
wellness.
area. There is a gray area. Don't get me wrong. I know that. And what ends up establishing that is the course or the case records over time. If you look at the handout that I've got on there, there's this one. I mean, there are a bunch.
Let me see
of
if I
case
can
records.
find it.
Yeah, it's just a link to a Word you pull up a Word document. But it was, let's see, which one was it? It was, yep, Mugler versus Kansas in 1887 that said that if you closed down an inappropriate use, that you didn't have to compensate the owner for it because the city was doing their job.
Mm-hmm.
And in another case in 1909, Hadacek versus Sebastian, you don't have to remember these. It was saying that this goes further into nuisance areas and not just life and death situations. And then it got extended in the 1916 in the Manhattan zoning districts, basically saying that heights of buildings affected other properties, and so that the city had a power to regulate the heights of buildings. Otherwise, property might be put in shade or, all kinds of things. So it was extending it out to a little bit more of an aesthetic side to some extent. And then the Village of Euclid versus Ambler Realty Company basically established the right of zoning, generally speaking. It was sort of the capstone of that time. But what it was dealing with was Euclidean kind of zoning, which is two-dimensional by and large. And then we have the first historic preservation case, which was Penn Central Transportation versus New York City, where they were proposing a big building on top of the historic structure.
Mm-hmm.
And now, the zoning is pretty well established. And if anything, zoning is too popular. People come, especially the citizens, come to depend on it more than anything. And you find a lot of arguments about zoning and not about community building, if you know what I'm saying. And so there's still a political edge to this, right, left, and center. And the thing that seems to be occupying the sort of, especially the rights view at this point, is this idea of takings. And so what I'm going to do, I have a short video that deals with Kilo versus New London. I didn't show that last week, did I? I don't think I did. I didn't have access to it. That's right. Where you're looking at it from the Cato Institute side, which is a significantly right-leaning institution. I thought it was only fair, since I'm a little left-leaning, that we mix it up just a little bit. But they're looking at it from that standpoint. So what I'm going to do is I'm going to share screen and go to, I think it's that one. No, that's, well, I can get to it. That's fine. And here we are. I'll go to content. And today's class, down at the bottom, you see the link to Kilo versus New London. Here we go. You ready?
This is the so-called takings clause in the Fifth Amendment. It enshrines your right to private property without undue government interference. Traditionally, takings for public uses included highways, schools, and other government-owned and operated projects. In 2005, the Supreme Court turned that notion of public use on its ear.
Economic development, the payment of higher taxes or the creation of more jobs is now a public use under the Fifth Amendment to the U.S. Constitution, a very dangerous precedent that the court set. But as I mentioned, that has led to this this backlash against what I think it's fair to call the most universally despised Supreme Court decision, perhaps in its history.
My name is Suzette Kilo, and the government stole my home.
Suzette Kilo is an American hero. She is a woman who stood up for her rights, and in the process stood up for the rights of all Americans. She was a homeowner in New London, Connecticut, that simply wanted to keep something that was incredibly valuable to her, the first home that she ever owned.
For Suzette Kilo and her neighbors, that Supreme Court decision was a profound disappointment that capped an exhausting legal battle.
Over 10 years ago, I was lucky enough to find a great deal on a house with a terrific view of the Thames River, the Long Island Sound, and the Atlantic Ocean in New London, Connecticut. I spent every spare moment fixing it up and making it the kind of home I had always dreamed of. I'm sure you've heard the expression, location, location, location. Well, this was the wrong location, only I didn't know it yet.
Just after Suzette Kelo bought her little pink house in 1997, the Pfizer Corporation announced it would build a massive new research facility in Kelo's Fort Trumbull neighborhood. The city council approved plans in January of 2000 to help Pfizer acquire the land it wanted in New London. The plan made dramatic use of eminent domain. It was all in accordance with state law.
The group that had the power, I think, also had some arrogance. And I think they understood that the law did, as the law was written in Connecticut, they did have the power to do what they were doing, as wrong as it seems. And as long as anybody was going to challenge them or fight them, they were going to enforce the law and exercise it no matter what. And I think the more the homeowners dug their heels in, the more the people with the power dug theirs in and said, well, we'll show you.
The homeowners who wanted to stay were served with eviction notices the day before Thanksgiving in 2000, but the legal battle between the Fort Trumbull residents and the city continued for 5 more years.
The Supreme Court has agreed to decide if governments can seize people's homes and businesses for economic development projects.
The High Court heard the case in 2005, and it was to be the most despised Supreme Court decision in many, many years.
What the Supreme Court basically said was our land was only our land until someone else could make better use of it and pay more taxes.
Justice Sandra Day O'Connor wrote in her dissent, the fallout from this decision will not be random. The beneficiaries are likely to be those citizens with disproportionate influence and power in the political process, including large corporations and development firms. Justice Clarence Thomas wrote in his dissent, something has gone seriously awry with this court's interpretation of the Constitution.
If there's anything that I think should take high priority in America, it is the protection of private property.
This is something every American and certainly every member of Congress can identify with.
Reaction to the 5-4 decision was immediate and forceful.
As a result of the Supreme Court's unbelievable ruling, a majority of the states have passed legislation offering more protection to American property owners.
They certainly felt the pressure of the public. I mean, a lot of legislators told me as I was talking to them and lobbying for this legislation throughout the country that they've never had phone calls like they did in reaction to any court decision, whether it's from the Supreme Court or any other court.
The reason this case became what it is today isn't because the Supreme Court said 5-4, you can do this. It's because how the general public across the United States reacted to that decision.
And though it may be a small consolation, the project that cost Suzette Kelo her home has essentially gone nowhere.
3 years later, Kelo's house has been torn down and the lot where it once stood is vacant. In fact, Real Clear Markets reports that there is no new construction in the area because the city-sponsored developer has been unable to secure financing because interest in the project is minimal.
There is absolutely no new construction in that area whatsoever.
And there's nothing there, nothing at all.
They haven't built a thing. They've knocked a lot of things down, but they haven't built anything. And as far as job creation, job stimulus, the only jobs that have been generated there have been for demolition crews.
There were 78 houses there, 78 tax-paying residents. Now there's nothing there. There's certainly no taxes.
There's likely to be no new development in that area anytime soon.
All it is now is a dust bowl, really. And I really hope they choke on the dust.
I think ultimately the Supreme Court will hear this issue, and I think they will reject Kelo. I think Kelo is one of those decisions, like Plessy versus Ferguson and Korematsu, the case that upheld the internment of Japanese citizens, is destined to be overturned. And I think it's only a matter of time before that happens.
Before we get into this,
They promised an economic.
anyway, you get a sense of it. So if you think about it, just trying to take, I mean, this is obviously a very conservative approach, but it does speak meaningfully to people's concern about being safe in their own homes. And I think that's a reasonable thing to kind of worry about, especially given, that we are living in this country, and that's been part of our traditions. But if you think about it, what was different about this than what was happening with urban renewal? Where the only difference is that the people affected with urban renewal were almost entirely African American, inner city people, and this is affecting people who are not necessarily, who are just in their maybe blue collar, but they certainly are not all African American. So there's that thought, but nevertheless, it is also then ironic that all the quote unquote right thinking liberal people, you know, were quite willing to do this in the name of economic development, even though they condemned what happened with urban renewal. So it's kind of an interesting topic. I haven't seen this one. This one just popped up as another one a few years later. It might be worth taking a look at if you don't mind, just because there's been a lot of follow-up, which the text describes. Out in Oregon, they passed a law that said, you know, any takings at all had to be compensated for, which basically got rid of zoning for all intents and purposes. And then that was walked back. And then it went back and forth through a couple of court cases. And, you know, right now it's still subject to a certain amount of disagreement. So I just am interested in what they have to say, if you don't mind. Is the video quality okay?
Yeah, that's all great.
Okay, all right, here we go.
Economic development project that would really revitalize the neighborhood, that would provide tremendous benefits.
What they got was exactly nothing.
10 years ago, the Supreme Court ruled that governments may seize property under eminent domain solely for economic development. That decision, which cost Suzette Kilo and others their homes, is known as the Kilo decision. Put another way, more tax revenue is a sufficient reason for governments to seize private property. In the Kilo case, as in many cases of eminent domain for economic development, the projected benefits never materialized.
To this day, nothing has been built. Only feral cats have really been using the property regularly. There is now a plan to build a memorial to the victims of eminent domain. That will be development perhaps of a sort, but certainly not the kind of bonanza that was initially expected.
The public reaction against Kilo was overwhelming.
No Supreme Court decision, certainly in recent history and perhaps in the history of the court, has sparked such a backlash that has yielded such tangible results.
Since the Kilo decision came down, 62 communities representing more than 16,000 homes and businesses successfully opposed the use of eminent domain.
Kilo was a very close 5-4 decision that caused a lot of controversy. It thereby broke down the pre-existing consensus under which most experts simply assume that everybody agrees that a public use is just whatever the government says it is.
The eminent domain public use clause is a provision of the Constitution that actually is one that is fairly easy to figure out. Utilities are public uses, railroads are public uses, because everybody has the right to use the public transportation, to use the utility line. A big box retail store is not a public use.
Courts should be very comfortable looking at the facts. Does the project actually exist? Is the stated purpose the real purpose? Do they need this property? All of those things are just ordinary factual questions that courts consider all the time, but they don't want to do it in eminent domain. They should treat these cases like every other case and judge them.
45 states have passed eminent domain reform laws, and while I think many of those laws are not very effective, there are some that are really good. And finally, a number of state Supreme Courts have repudiated Kilo as a guide to the interpretation of their state constitutions. So although Kilo certainly hasn't fully resolved the problems in this area, the debate it has kicked up has made things better than they were before.
The first thing the courts need to do is say that eminent domain for economic development is unconstitutional.
Interesting. All right, let's stop share for a sec. What was your impression, guys? The way it's presented there by the Cato Institute is obviously slanted, but it makes a reasonable enough case legalistically. What were your impression, Matt? What do you think?
Yeah, so I actually watched that video in a real estate class that I had this semester, and I don't know, I think it's kind of absurd that the government can just go up and take something without any warning. But yeah, I mean, I'm definitely more leaning towards the Cato side.
Yeah, well, I mean, if you just look at it on the face of it as how they present it, it certainly seems to be that way. You know, what happens is, and especially in city planning, there's a lot of gray areas. You know? And anyway, so Gabriel, what do you think?
So I think that in this case with Kilo versus the city of New London, it's very obvious that New London is at fault, that they're in the wrong, that their actions should be unconstitutional. And I thought it was a very smart comparison to urban renewal, and the irony of pointing out that that hadn't created quite the same outrage as this case had. But I think that we should not want urban renewal to happen either. So it's just as important to say that this case shouldn't have happened. Now, I think when it comes down to considering whether this speaks to the rightness or the wrongness of eminent domain, it's
Well, is
looking
it
at these
eminent
cases.
domain or is it profit seeking or higher taxes?
Right.
Yeah. Okay.
And you definitely do have that profiteering, and it's and that's the point of why I think it makes it so easy and so clear and cut in this case to say that the city is wrong. But I think eminent domain is a really hard topic, because even in cases where people are happy with the result, there still can be a lot of misgrievances and losses and a lack of justice in some circumstances. Like, I'd think about the boulevards they make in Paris, right? And obviously that's not America, but they basically had to tear down huge amounts of neighborhoods in Paris and basically just displace a huge amount of poor people. Obviously that was also back when there was a different standard of morality in between the public and the government, but generally people were happy with the boulevards. So
well, yeah, just to interject a historical footnote here, right? Before they started building before they started building the boulevards, they had mass revolutions. This is 19th century, just after the French Revolution, and they restored the monarchy and sent the soldiers in to fight the citizens. They killed 40,000 Parisians on the West Bank, and decided that in order to keep the peace, they needed to build these major roads to cut up the other small areas that were the hotbed of dissension.
Right.
So I mean, people are happy with the boulevards, those who are still left alive.
Yeah. And maybe that speaks to the point of how America is supposed to be different, because America is supposed to be a democracy. So when you look at those historical events where you see this tyranny that kind of gets waved off, it's because, there was revolutions, it was bloody, it was monarchy, that's what happens. But America is supposedly supposed to be different.
Well, let me find, never trust anybody that says there's only two points of view, especially in law, right? Right. It's not eminent domain or no eminent domain. It's not takings or no takings. Look at the case of the Charleston Place, which is the major hotel there on King Street and Market Street, right? That was a bunch of individual businesses that was run down. Of course, you could argue that the city disinvested from that area for quite some time and made sure that it ran down. But, there was, it was kind of, how shall I say, it was kind of wild and woolly. There was a bar there, fancy bar in an old department store that had the nickname the Gun and Gonorrhea Club, because everybody went there to dance their, 1970s style stuff. And then there was a strip joint. There was Corinthian Room over on Meeting Street. It was kind of, it wasn't exactly the image Charleston was trying to project,
Yeah, wow, and I didn't know that stuff was there.
Yeah, yeah. It's really kind of interesting. And yeah, I remember the guy who owned the Gun and Gonorrhea it was actually called the Garden and Gun Club, but we renamed it. He had a big macaw on his shoulder, and he had only one leg, and so he would go stumping around with this bird on his shoulder and looking like a pirate. It was kind of weird. But anyway, so it was kind of a really funky area, right? It wasn't what you see today. Well, the city used eminent domain to buy the buildings and tear them down. They obviously tried to work with the preservation establishment. It was controversial because the city was trying to build something too high initially, and we had to go back and forth a long time to get that thing built. And so, that was a case where, John Q. Citizen was perfectly happy with their strip joints and their bars and their, seemly environment, unseemly environment. But yet the city decided we need to redevelop. And looking back at it now, everybody's really happy with King Street and thinks that the Charleston is a success story. And, Charleston Place was a big part of that in its day, still is, I think. And so, they invested heavily in the place. They invested $20 million of city money to build a parking garage back there, and it didn't get paid back until like just the last couple of years. So,
Really?
was that was an example of taking, but was it appropriate just for extra revenue, or can you define it more in terms of public health, safety, and welfare, and that it's created a place that we all now really like? So it's great. It's not black and white.
Yeah, that's definitely a good example of that, because at the end of the day, a lot of people would be happy with the result, but you can argue that there is tyranny there. And ultimately, whether the good outweighs the bad is for the people who enjoy it now to decide. And I think they like it. So I guess history will remember it as good.
Yeah. So you can you get a feel for it. Now, when we look at Kelo or we look at other cases, we're looking at it with hindsight, right? And with hindsight, we get a lot better vision than whenever we're living through it. Trying to decide on, what's the right approach when you're in the middle of it takes a lot of judgment. And this is something where you have to be able to balance contravening forces and try to come up with something that at least makes sense in your own mind. And I think the difference really is whether the city fathers, the mayor, the people in charge really do love their city and are trying their best along ways. In the case of Mayor Riley, cultural avenues, downtown revitalization, that sort of thing, that people had pretty much bought into. But you'll never get total buy-in by everybody, will you? Certainly the kind of hipsters that were using that place didn't appreciate being shoved off. But, and I do have fond memories, I have to say, about some of those places you might get from their colorful sort of, shall we say, businesses. But what was it? One more story. The first bar I ever went into in Charleston was there now, sort of on, what was the name of that road? Cumberland, that's right, just before you get to East Bay. On the right there is that big complex that's the timeshare. Anyway, that used to be, in that area was a real muddled bunch of warehouses, and in one of the warehouses was a bar, and it was kind of wild and woolly. There was newspaper that was being used as wallpaper, and there were dirt floors. Anyway, the first time I went in there, I was having a beer and talking to somebody, and I felt somebody chew on my ear. And I turned around, and a horse had walked into
What? That's hilarious.
Like, okay, yeah, this is a different place. This is a different place.
Definitely. And I'm sure that there's lots of people who will seek out that interesting, unique character. But I guess to your point, the places where you often find those crazy, unique bars and places where the hipsters can take them over and do whatever they want with them are typically cities that aren't in good shape. It's cities that have been made so cheap and so run down that hipsters can come in and buy whatever they want and do whatever they want. So in a way, it's almost, you almost have to let go of that stage if you want to get to a stage of maturity in the city that you can say should be the goal of a city. It should be the goal to be sustainable in an economic sense and maybe a little bit more stable.
Well, that's a little bit of a reductionist view.
Sure.
I think generally speaking, you are, not far off. Certainly the way Charleston's developed has proven the efficacy of what you're talking about. But, there's people like Jane Jacobs, for example, who we all revere for what she did to stop Robert Moses. Also wrote another book called The Economy of Cities. And it's one that people don't usually look at very much. She also, her last book was called Dark Days Ahead, and I think we're living in them, but she was very prophetic in that way. But in the book Economy of Cities, she argues that there needs to be a part of every city which is just not pretty, where people can get in and find something cheap and do something original and not have to worry about overheads. And so, you know, there's a lot to be said for that. You know, it's not, you might call it maturity to move out of that, but at the same time, if the city doesn't have that kind of incubator, then it's not as vital as it could be, it seems to me. And that we need to find room for all of it, one way or the other.
Definitely.
Yeah, so that I'm just nuancing the argument just a little bit, just to point out just how gray this stuff is when you start to try to, you know, use a really big brush to describe it.
Yeah, sure,
You know what I'm
definitely.
saying? So, and it also points to, you know, the difficulties in law in trying to make universal applications. This is one reason why in law, it's case law. In other words, you have to have an incident where people are affected by it, and they will rule usually on the combination of the constitutionality as well as what case law is out there and how this has affected that particular plaintiff.
Right.
Okay, and so it is a question of scrutiny and careful consideration. You can't just make a sweeping generalization and assume that it'll apply in every case, which is fun. That's what makes law fun. Usually I have an attorney named John McCullough in my planning meetings, but he's not been feeling well. And he likes to, you know, sort of embellish these stories because he's got a lot of them himself. I mean, this is what lawyers do, is get involved in this kind of stuff. But anyway, so yeah, there is a lot to know about sort of the legal side there, and I've tried to distill it in this little handout so that you can at least be somewhat aware of the court cases and get a feel for it. What I want to do, I think, is to spend a minute dealing with another legalistic portion of it, which is all the kind of terms of reference that we see talked about when we go to planning meetings and, you know, all that kind of stuff. And so I just want to take a minute and see how successful this is. I've never tried to do it this way before, but I have what amounts to sort of flashcards where we talk about different principles and see if we can get it right. And there's a way to kind of engage the group here, all of three of us, right? I haven't taken the whole thing yet, so I might get some wrong myself, but I hope maybe you can bear with me here. All right, I'm going to share screen again, and I'll go back to, I think it's this one. Yep. And here we are. Nope, that's not the one, sorry. But I can get it. I just go back to our, here, there, and everywhere. All right. Go to Oaks. Here. All right. This is, I mean, this is a bit arcane, but we'll try to make it as fun as we can, and I'll try to tell you some stories as we go along to make it more meaningful if I can. Well, here we are, May 21st. Go down to the bottom. There's a zoning review here, which I think is worthwhile because these terms of reference.
Mr. Ward, I think we're looking at the wrong screen.
Oh, okay. Let me go back to.
Yeah, we're looking at Google My Charleston.
Okay, then I will start sharing again and try to get the right one. Okay. I think this is, the right one. It's supposed to be anyway. Is that it?
Yeah,
Yep.
I see.
Yep. Okay. So go down to the zoning review. This is a little, whoops, I have people waiting. Where are they? I need to find out, where are they waiting?
I think there's a waiting room where you can let people in.
Oh, okay, sorry. All right, let me see. Breakout rooms, where are my waiting rooms? Wait, back up here, no, not there. Not gonna end the meeting. Emma's made it on. Hey, Emma. Did you have to wait in a waiting room? Emma?
Oh, hey. Oh,
Yeah.
sorry. I didn't know you were talking to me.
Yeah, did you have to wait in the waiting room?
No, I didn't. I just was let in.
Okay. Yeah. Okay, I'm trying to figure out who's in the waiting room. It's not showing up on this meeting. They must be in a different meeting. So I'll open up the different meeting in my other computer and ask them to come to this one. It's
Oh,
weird.
that would make sense.
Oh, it may have been me because I just clicked on the Monday's recurring meeting on accident. And then I went to this one.
Okay,
That
okay.
may have been me.
Well, Zoom doesn't let me schedule multiple days with the same recurring meeting, so I have to set them up twice.
Yeah.
It has another meeting in progress. Okay. But who, all right, well, it's not, so maybe it was just you after all. No, it's not letting me in. So I guess maybe it was just you. That's good. I'm glad. I don't want people sitting around waiting for nothing.
Yeah.
Right. So I'm going to deal with this. Cancel. And I'm still in with you guys, right?
Mm-hmm.
All right, cool. Yeah, these are some flashcards. We just went through a description, Emma, of sort of the burning issues of the day and planning as it relates to, you know, how we do things with the legal system that we have. It has a lot to do with
Right.
takings. There's a video there relating to Kelo versus New London, which I can recommend to you to have a look at. And it kind of describes the situation from sort of the Cato Institute's point of view. They're very strong private property rights people, but we were just reviewing kind of the gray areas there. They present one point of view there, but there is another way of looking at it, at least one or two or three, right?
Uh-huh.
So, in looking at this, and not everybody speak up at once, but describe what an eminent domain is. What was the word I just used? Starts with a T. Taking. So eminent domain is actually taking another person's property. Let's see what it says. Each landowner with a fee simple absolute title may find the use of real property is often subject to governmental restrictions. Under the constitutional right of eminent domain, the government can take property for public use if it pays just compensation. And the tricky bit here, of course, is public use. And how do you choose to interpret that? Police power. What's police power all about? That's where the cops show up, right? But in a more general sense, how does cities exercise police power? Remember the three terms that we use to try to justify zoning?
Health, safety, and wellness.
Health, safety, and welfare, exactly. Wellness might be a very current way of saying it, but traditionally it's been welfare, yeah. So that's, you know, what it's supposed to, and that's the way it's been set up all along. The question of welfare, of course, is one subject to a certain amount of interest. So there it is, health, safety, and welfare of society is subject to private deed restrictions, but that's something different. If there's a conflict between public restrictions and private restrictions, whichever is more strict will apply. That's another one of those things where in our country right now, we have a lot of homeowners associations that are passing laws about who can do what in their area that really amount to extra constitutional law and is being subject to some review at this point. For example, the Sun Cities that are being developed, like a very large one right near Beaufort. People buy into it realizing one reason why it's affordable for them is they don't have to pay the educational portion of the local taxes. They're exempt from that. Or they don't allow, you know, young people to live there. You have to be either children or old. And this represents part of the association's sort of requirements, but it's not really constitutional, is it? So this is an interesting sort of area of emerging law right now, all of the various covenants that are out there. This is interesting, and it's kind of, how shall I say, intuitive, a budding permit. That's not in the text, so let's jump over to the definition. It's basically giving people permission to do things before they do it, prior to beginning construction, which is kind of interesting. Condemnation. So this relates to eminent domain. Condemnation basically is, what do you think? Emma, you probably heard the word, this building is condemned before. So how would you characterize condemnation?
I would say probably like you can't use it anymore. So the government would say you can't live there, you can't like hold a business there anymore.
Right.
You have to get out.
Exactly. In order to acquire it through eminent domain, usually you have to condemn the property. And usually you've heard of condemnation because of safety violations and stuff like that. So that's usually how it's applied. Yeah. Judicial administrative procedure, take public property for public use, private property for public use. Eminent domain, okay, this is essentially a little bit different. To take both state, the right of government to take necessary public use with just compensation. So eminent domain requires compensation, police power does not. So therefore zoning is an element of police power, and because you are zoned a certain way doesn't mean that you're due any compensation. This is something that people object to a lot, but that's generally how it's interpreted. Does that make sense? Good. Non-conforming, this is not firming, it's conforming use. This is something you hear a lot of in zoning discussions. Whenever a new zoning district gets made, then obviously not everything in the zoning district probably will comply with the newly formed legislation. So it was a permitted use that was put there before, but no longer conforms to it. It's called, of course, a non-conforming use, not confirming use. And you'll hear that used a lot. There's some question about non-conforming uses. For example, in the city of Charleston, you know, you'll have an ancillary building, say a secondary building built on the property that doesn't conform to the current zoning, but it was there before. And now the property owner wants to do a lot of improvement and really spruce up the place. It's a real controversy as whether those non-conforming uses have to be demolished at the time when they undertake major renovations. So that's kind of the burning issue in Charleston. Police power, I think we've kind of talked about that. What would you say would be your thoughts on that, Mr. Duhan?
Isn't that what we talked about with like the health, welfare, and like social?
Right. So when you say police power, think about it this way. The police don't give you money when they pull you over because you're speeding. You give them money, right? So the police are not due money for what they're doing to you. They're basically, you know, you have to pay out. It is something that is being done for the health, safety, welfare. Right? Okay.
Mm-hmm.
And zoning, Gabriel, we've talked a little bit about around zoning, but how would you define zoning and how do you see it fitting in this conversation?
So zoning would be the use of police power to define land uses by region?
Well, yeah, I think you should have stopped before you got to the method because there are so many different methods that people can use to enforce zoning, you know. But yeah, so it's using police power, which is uncompensated, to control land use. That's, I think, a reasonable definition. Regulation of structures and uses, I think we need to probably say that too. Affect such things as use of land, types of structure, building height, setbacks, and density. Okay, cool. Difference between a variance and a non-conforming use. So let's talk about what is a variance. Do you have any idea, Emma, what a variance is?
I don't really think so.
So you'll see this used a lot in the city of Charleston. The board of, or the what's it called? Board of Zoning Adjustment deals with BZA, that's right, Board of Zoning Adjustment deals with variances. And because for a long time, the city of Charleston had a really, crazy zoning ordinance that required setbacks and everything else, and they tried to apply that downtown where nothing was set up that way historically, then they all became non-conforming uses, right? But a variance is a little bit different. A variance is where a place is zoned a certain way, but because of what you feel like are hardships that imposes on your particular property, your particular circumstance, you go to the BZA and you say, look, because I can't build within 5 feet, I can't build at all. Or I can't build what needs to be built and it's not unreasonable what I'm proposing to be building. Then you can get a variance to depart from the zoning ordinance in a case-by-case basis. Let's see what they say. Variance exception to the existing zoning, whereas a non-conforming use is a grandfathered in situation. So yeah, that's it. There's just a few more of these, I think. Describe the difference between eminent power, police power, eminent domain, police power, because police, you don't have to give money. Eminent, you do need to give money. That would be one easy way to say it. You can nuance it a little bit more. All right, here's into a different set of things. I'm looking at this now. They're asking questions from a couple of different points of view to make sure that you have a handle on the overall principle. Were there any questions about those basic ideas? Okay, we're good. So a floodplain control, and this is something we face here a lot in Charleston, is an example of which type of governmental power. Is it eminent domain? Is it police power? Is it subdivision? Or is it an attachment?
What is a floodplain control?
Well, like you can't build in the floodplain.
That makes sense.
Yeah. So my thought is that it's police power. Just because usually you don't require recompense. But the difference might be that if you have an existing building in a floodplain, of which we have many in the city of Charleston, can we do away with those simply by police power, or do we owe them money? Let's find out. I'm going to check police power. It's police power. Under the police power, the government can pass regulations to protect health, safety, welfare of the general public regarding types of structures that are accessible to floods and requirements. So legally, I guess the city can. Can you imagine what would happen if the city exercised its police power to tear down a lot of vernacular structures along the water's edge? Yeah, there'd be a lot of pushback from preservation people, wouldn't there? Huh?
Yeah, I was just going to say, probably wouldn't go over too well with the public.
Yeah, right. But in theory, they could do it. Or maybe not. Maybe it's not that easy. One owner wishes to develop a beauty shop in his property in an area zoned single-family residences. What type of legal process should he be using? Non-conforming use, downzoning, building permit, or variance? So you might know it, but I need to describe these other terms so that you have an idea of what they mean as well. What do you think would be the case? Anybody want to venture a guess?
I would guess that it would be variance.
Because it's a different use, right?
Mm-hmm.
Let's see. Yes, you're right. Change in existing zoning. However, let's go back and look at these other things. Non-conforming use we just discovered was something that is no longer conforming, but when it was built, it was, right? Cool, that's easy. Downzoning, that's a term we haven't used much. What is downzoning all about? So it's kind of, how shall I say, intuitive based on that. So if you have a parcel and you're zoning it down, it's kind of like you're basically saying, okay, I have a parcel that I can do a commercial enterprise on, but I want to just do a residence, right? And so that's considered a down zone because it's less intense use of the property. Okay, what do you think would be the advantage of down zoning? So you pay taxes on your property, right? And if your property is zoned commercial, you're probably going to pay more taxes than if it's zoned residential. But if what you want to use it for is residential, then you don't want to have to pay those extra taxes. Therefore, you would try to get it rezoned with the lesser zoning, the less intense zoning. Does that make sense? Yeah. And then building permit, that really doesn't apply to a lot of this stuff. You have to get a permit to build. And generally speaking, as part of the permitting process, they first require that you have the zoning in place before they look at the details of construction. Let's see what it says if I were to click that. Oh, apparently you're correct no matter what you click. Never mind. All right, what's the next one? The zoning ordinance could validly affect all of the following except, so remember what the definition of zoning was. It's the structure and use, right? So height of a building, well, that's structure. Proportion of building area to land area, well, that again, that's kind of the structural dimensions of the building. The use of a building, yep, structure and use, land use, that's definitely. The amount of rent charged unit, tenants. Well, that's kind of sticks out like a sore thumb, doesn't it? So yeah, I think it's the amount of rent charged to tenants. Yep. Let's try this one. All of the following are used in municipal planning, city planning, urban planning, except building codes, housing codes, subdivision regulations, and subdivision covenants. Anybody have a guess? Remember how I talked about a lot of homeowners associations have got their own covenants or their own rules out that are, you know, maybe very restrictive, but are not part of the Constitution or anything like the law otherwise. Those would be subdivision covenants. Subdivision covenants are private and not public restrictions. That's what I mean about extra constitutional, you know, sort of control of property. All of the following examples of public restrictions except police power, encroachment, eminent domain, and taxation. Public restrictions. Well, taxation doesn't seem to fit there, does it? I'm curious. It could also, I guess, be interpreted as encroachment, but I don't think so. Oh, maybe so. Encroachments are physical encumbrances such as overextending eaves, trees, driveways, or building. Okay, I was wrong on that one, guys. It's encroachment. Let's go back to the question. So their example of public restrictions. So encroachment is, okay, now I see it. Encroachment is where you would get a variance for encroaching on a setback. In other words, getting into it. But I'm not sure I entirely think that's, well, it depends on how you see it, right? Anyway, do a couple more of these just for the fun of it. Eminent domain, taxation, police power, and S-sheet are restrictions on the ownership of any property. I don't even know what S-sheet is. Restrictions on the ownership of any property, benefits belonging to the owner of real property, private restrictions on personal property, or factors that affect only owners of the land abutting government-owned properties. Let's find out. Restrictions on the ownership of any property. In practice, S-sheet would have the least frequent impact on real estate ownership. Interesting. Okay, well, there's a new term for me there. So this is just a little few flashcards to kind of get us familiar with the basic ideas of eminent domain and police power and play around with some of the terms you commonly hear used in planning and zoning meetings. Like I say, there is a planning meeting where they discuss the overall idea of a plan, and that's frequently where planned unit developments go into, where they talk about whether or not it makes sense in light of the whole character of the neighborhood. And variances, or the Board of Variance of Zoning Adjustments, or that handles variances, has to do with case-by-case studies of whether there is a what amounts to a takings of the property because of the zoning, or if it is reasonable under those particular circumstances. Right? Cool. I think we got that. So what I'd like to do is just take a break and get a drink of water, and then go back and talk a little bit further, excuse me, about, are we still on this one? Yeah, good. Some of the social responses that we looked at before and some of the issues that come up when we start talking about the social side effects of all of this stuff. So we'll try to go through some of this, yeah, master plan, federal role, planning and politics, social issues, yeah, try to get through this slide a little bit more and give it a bit more time than I gave it last time. So I'm going to grab a quick drink of water if you don't mind. I've been talking for about an hour, so I kind of need it. I'll be right back. I'm going to pause recording so I can split it up into 2 sections.